Losing someone you love is hard enough. Dealing with the paperwork and the court stuff afterwards, that just adds to the stress. In this video, I'll explain exactly what probate is, how long it usually takes in Texas, and what you need to know to avoid the delays and unnecessary stress. I'm attorney Aaron Miller, and about 15 years ago, I saw how tough it is for families when they lose control of their assets. So I decided to dedicate my career to helping people plan and protect their future. If you'd like to speak with a trusted attorney, please give us a call today at 214-292-4225. Let's break it down so you know exactly what to expect. What is probate in Texas? Probate in Texas is a court-supervised process that ensures the deceased estate is distributed according to their wishes if there is a will, or according to state law if there isn't. This legal process starts when a personal representative, usually the person appointed as executor in the will or an administrator, files an application to be appointed to be in charge of the estate. Now, if there is a will, then the deceased's original will gets filed with the court's office. At the start of the probate process, it's critical that all required documents are filed correctly. If there is a will, everything really revolves around that. The will says who should be appointed as executor, and that person takes on the responsibility of managing the estate as soon as they're appointed by the court. If the decedent passed away without a will, then the court appoints an administrator to manage the estate in accordance with Texas law. Now, once the will is filed and approved by the courts in Texas are more or less hands-off in most cases. We call that an independent administration. And what that means is the executor can do what they need to do without having to keep running back to the court for approval. And after being appointed, the executor then begins the process of inventorying and valuing the assets. They must also notify any beneficiaries and interested parties in the probate proceedings. From there, the representative will handle several important tasks, including notifying creditors that an estate has been opened, paying off any valid outstanding debts and taxes owed by the decedent, the key word there being valid, managing the estate's expenses such as funeral costs and court fees, ensuring any final wishes related to the distribution of the estates are honored. They're going to be distributing assets to beneficiaries per the decedent's will. The personal representative must act in accordance with Texas probate law, which can be complex. This is where a skilled probate attorney can be invaluable. They'll guide the personal representative through each step, ensuring all legal requirements are met and helping to prevent any potential disputes. Who can probate a will in Texas? In Texas, probate starts when an interested party, usually the appointed executor in the will or a close family member like a spouse, child, or parent, files an application with the court. But before moving forward, they must prove they have the legal right to act for the estate. The court then validates the will if there is one and verifies that the executor is eligible to serve as executor. Now, if the named executor can't serve, then the successor executor, if there's one named in the will, may then serve. Now, if there isn't any successor executor named, or if there isn't anybody eligible, or if there isn't anybody who's willing to serve as executor, the court then may appoint somebody else to serve, and we would call that person an administrator. Now, whether you're named executor or you've been appointed administrator, you then have the authority to begin probate once the court has approved your application and you receive letters testamentary or letters of administration if there is no will. These documents show you've been through the probate process and that you have the court-appointed authority to manage the estate. Working with a probate attorney can help ensure the process runs smoothly and give you confidence every step of the way. How long does probate take in Texas? The probate timeline in Texas depends on factors like complexity of the will and whether disputes arises. Now, for straightforward estates with no challenges, probate usually takes between 6 and 9 months. But if there are disagreements over the will's validity, asset distribution, if there's conflicts among the beneficiaries, if the will is handwritten or has some other issues, the process can stretch to a year or longer. Several factors influence how long probate will take, such as complexity of the estate. The more assets and liabilities the estate has, the longer it's probably going to take to settle. For example, an estate with multiple properties, a large amount of investments or business interests will require more time to evaluate and distribute. You might have disputes between beneficiaries or creditors. Disputes often occur when beneficiaries feel the will is being misinterpreted. If the beneficiary feels like the circumstances surrounding the will signing was fishy, or if creditors challenge the validity of the debts. These disputes can also slow down the process considerably. Texas does offer a simplified probate process for small estates. If the value of the estate is under $75,000, excluding homestead and exempt property, the process can be completed much faster, potentially in a matter of weeks or months. However, this sounds great, but it is often much more difficult to use this process because some courts just don't like it. Right now, as I record this, it's impossible to get one of these through the courts in Dallas County, for example. Executor's efficiency. The personal representative's efficiency and ability to follow the necessary procedures procedures can also affect the timeline. A skilled executor or administrator will expedite the process, while delays in administration can lead to a longer probate timeline. The probate process involves multiple steps, and while the court doesn't necessarily have to focus on everything in particular in Texas, it's still essential to follow the proper procedures to prevent unnecessary delays. What legal documents are required in Texas probate? To probate a will in Texas, several important legal documents are required. Here's a rundown of some of the documents you are going to run across. The original will. The most crucial document of all is the original will of the decedent. It must be filed with the court for probate. You'll also have an application for probate. This document is filed with the court to officially request probate and initiate the process. You'll have an order admitting the will to probate. Once the court approves the will, it will issue an order admitting the will to probate, and the order legally authorizes the executor to begin managing the estate. Letters testamentary if you've been appointed as executor, or letters of administration if you've been appointed as administrator, is a document issued by the clerk of the court that says that you've been through the probate process and the court has appointed you executor or administrator, and allows you to act on behalf of the estate, to manage all the assets that are in the estate, pay debts, and then distribute assets according to the will or according to Texas law if there is no will. An inventory is a list of assets with fairly specific details about those assets, such as the last 4 digits of the account number, the type of asset or account that it is, and what the value of that asset was when the person died. This will probably have to be filed, but we may be able to avoid it by filing something called an affidavit in lieu of inventory instead. If there's no debts, other than maybe a debt on a homestead, if the beneficiaries have all received a copy of the inventory and also a copy of the will. There's also a document called a notice to creditors, and now this is a notice that we have to publish in a newspaper you've probably never heard of that lets any creditors know that the decedent has passed, and if they have a claim they wish to pursue, they have to notify the executor, and they have to jump through certain hoops to make sure that their claim is valid. Now, there are other documents that your attorney may discuss with you, but those are the main ones. While probate is often necessary to distribute a deceased person's estate, there are ways to streamline the process and minimize the stress on your family. By knowing the timeline, what documents are needed, and being prepared for the cost, you can navigate probate with confidence. Most importantly, working with an experienced probate attorney can make the process smoother and more manageable. If you're ready to start planning or you want to understand your options, give us a call today at 214-292-4225. We'll walk you through what makes sense for your situation and help you protect the people who matter most. Now, if you found this video helpful, don't forget to like and subscribe. We've got more answers coming your way. Click the next video right here to stay informed.